Good evening and welcome to our Ohio Farmland Leasing Update webinar. We're really happy that you could join us this evening, and I guess I'm going to welcome you on behalf of all of our folks that are joining us here this evening and all of our presenters. And let me get to the right slide here. Okay, so my name is Barry Ward, and I'm the leader of production business management in the College of Agriculture at Ohio State University. And also on behalf of OSU Extension, I'm also the director of our OSU Income Tax Schools, and I'm really happy to be joined by Peggy Hall, attorney, OSU Ag and Resource Law Program. She's the director of the program, and also one of our newest employees, one of our newest team members, Robert Moore, who's joined us again after taking a pretty long hiatus and is owning his own law practice, and many of you know Robert, attorney, also now with the OSU Ag and Resource Law Program. So I feel a little bit outnumbered by attorneys this evening. I hope you guys don't overwhelm me too much, but we've got a lot on the agenda this evening, so I'm not going to spend a lot of time. I think you can see all of the different topics there laid out in front of you. I'm going to kick us off here in just a few minutes talking about some of the economic related issues to farmland leasing. And we'll share some data, and we'll also look at some of the economic indicators for this year, especially in crop production, and how that may influence cash rental negotiations and rental rates into this year and then possibly next. There's a number of things on the law side that we're going to be discussing: ensuring lease enforceability, statutory termination legislation, which is ongoing. That legislation is being debated, and negotiating conservation practices, and using leases in farm estate and succession planning. So we're looking forward to a full evening in an effort to get to know all of you better. We're going to throw out a polling question here right from the get-go. So you can answer these, and for those that haven't been with us on a Zoom webinar, this is all confidential. We don't see, your names don't pop up in terms of how you answer these, and we've just got 2 or 3 of these throughout the evening this evening. So I'm going to launch this first poll. Hopefully you're going to be able to see it. Just asking who you are, basically. We're just trying to get a feel for our audience this evening, and whether or not you're a landowner, landlord, a tenant farmer, or maybe both, or you have some other professional capacity. Just go ahead and select one and go ahead and end, or I guess choose that, and that will automatically be registered. I'll share the results here with everyone in just a moment, so you can get a feel for who else is joining us this evening and who the other participants are. Okay, so let me keep going while you all continue to work on that. The webinar resources, the availability, we have this, we have a website, and the PDF of the slides is available at this particular web page for you to access and download the slides if you so choose. Also, we're recording this webinar, and it will be available perhaps not this evening, but in the next couple of days. We'll have the recording of this webinar posted to this page too, in case you want to go back and review some of the topics that we have discussed here this evening. Okay. Let me go down page. Sorry, folks. Okay, here we go. Interaction with us. Okay, a question came up earlier. As this is a Zoom webinar, you're muted, so you can't interact with us by voice, but you can. There are a couple of features that you can interact. We prefer, if you have technical related questions, enter that in the Q&A feature, and we'll do our best to answer those questions throughout the evening. Also, if you just have a comment to throw out, and if we're going to also supplement some of the things that we're talking about by including web pages or other things, other access points, we'll include that in the chat feature. So pay attention to those things, and we'll be accessing those and trying to keep up as we go through the next couple of hours. Okay, I'm going to end the poll now, and I'm going to share the results. It looks like we've got at least the majority of landowner landlords and tenant operators. We've got a few and some that are both. A few educators, attorneys, lender, and some others. So a mixed bag as we see, and that's pretty typical with these webinars. Okay, there will be an evaluation. As you exit the webinar this evening, you'll be directed to an evaluation link. You can access that and give us a little feedback. It'll only take you about 3 or 4 minutes. It's pretty short, and it allows us to make improvements and add topics in these future webinars that we will offer as we go along. Okay, so just be aware of that evaluation, and we'd sure like your feedback. Okay, I will ask my comrades if they have anything to add before I launch into the first topic. Okay, Peggy, Robert, it's good to see you. Yep. And we'll be with you on the legal side here in just a little bit. Okay, I'm going to stop sharing that polling question. And this is a lineup of some of the things that I'm going to be discussing this evening. We're going to talk about the types of leases. We're going to look at a current economic outlook for Ohio crops. It will give us some direction as we kind of evaluate what the rental rate picture might look like. We'll look at some data, and we'll share with you the USDA data. We'll share our survey data that we conduct here in Ohio through OSU College of Food, Ag, and Environmental Sciences, and show you what our data is looking like in terms of cash rental data. We'll also share some other data that we have, so it will give you as complete of a picture as we can provide as far as the public information that is available that you can use to hopefully negotiate an equitable cash rental rate. And then we'll look at some of the outlook as far, again, we're going to look further into what are some of the fundamentals that are going to impact lease rates going forward. Okay, types of leases, and there are a number, and we're going to focus a little bit more on fixed cash lease issues and also rates, and that's the one that I have highlighted here in the middle. But if we go back and look, the old standard crop share leases, these leases are still used on a number of farms throughout Ohio, and the latest data that I have seen as far as crop share lease usage here in Ohio is somewhere around 15 to 20%. It's not a huge number, but it's still enough that it's meaningful for many of you out there as you use those. Cash leases, of course, are the predominant types of leases that are being used, and fixed cash leases are the ones that are the large majority of those cash leases. Now, we still, we're continuing to talk about flexible cash leases, and we have more and more of those. However, we're still somewhere between 5 and 10% only of all the leases out there are in some kind of a flexible cash lease form, depending on what survey and what data that you look at. I'll also discuss briefly what are indexed cash leases, not used very often, but they can be a tool in certain circumstances. Okay, real quick, crop share leases. I want to talk a bit about these as we kick things off. A traditional crop share lease, we're just looking at how we're going to be sharing the crop, the produce coming off of a particular farm, essentially in the same proportion or the same amounts as the expenses are shared between the two parties. As the tenant and the landlord share the expenses, that should then equate to the same type of sharing of the revenue or the produce coming off of a given farm. So those are the old standards. The crop share lease are still being utilized. And I've just got one more slide here talking about this. Now, we have an old fact sheet that's no longer even available online. If you want this fact sheet, you would have to reach out to one of your extension educators or reach out to me, and I'll be happy to provide it to you. It is a little dated. However, it still is, I think, can be very effective in walking you through the steps that you need to take in setting up a crop share lease, developed by a couple of our colleagues that are now retired. The two principal and the two primary types of crop share lease that are still being utilized in Ohio are the standard 50-50 crop share lease, where both parties will share roughly 50% of the cash costs. The tenant will provide all the labor, machinery, and equipment. The landowner/landlord will provide all of the land and any any costs that go along with the land. That's the pretty typical standard crop share lease. The other one that may be seeing a little bit of a comeback is the 1/3, 2/3 crop share lease, where the landowner is providing just the land and not sharing any of the cash expenses as the 50-50 crop share lease would be set up. But the 1/3, 2/3, or the 2/3, 1/3, however you want to phrase that, is the landowner would provide just the land and would receive 1/3 of the crop. So those are still in effect on some farms throughout Ohio, not the predominant kind of lease, but one that can be still utilized and be very fair and equitable. So we get that question from time to time, and if people are really struggling and trying to determine what that cash rental rate should be, then this might be a fallback position. Now, the problem being is that more and more these days, we see fewer and fewer landlords interested in some of the management aspects that go along with this, and fewer of the tenant farmers being interested in some of the complexities that it adds with including another management or another operator into the system. So that's part of the reason why we see fewer and fewer crop share leases. Okay, moving on. Here's the primary kind of lease that we're going to address, at least I'm going to discuss in my remarks here, is the fixed cash lease, where the cash tenant pays the landlord a fixed amount, usually part in advance for the use of the farm real estate, and receives all of the resulting production. The tenant pays all the costs and so on, and they get all the grain or the produce off of that farm. Now, some of these leases have been set up these days where there's a little bit more control over some of the production practices that the farmer might employ. The landowner might have specific objectives that they would like to see carried out in terms of environmental types of practices. And then we also see at times more stipulations in the lease regarding an upkeep in fertility, for instance. And so we see more of that these days. And there is some give and take with those things. Obviously, as the landowner/landlord requests more of those things, oftentimes that may impact the rental rate or the number of potential folks that are looking to lease the land. Okay, I mentioned briefly an indexed cash lease, and this is not utilized very widely, but this could be a tool that you could use to eliminate some of the headaches that go along with the periodic discussion about lease rental changes. And what I'm suggesting here with an indexed cash lease is that it's based on some predetermined parameter where the lease adjusts each year based on some public piece of information. For example, as we look at the NAS, the National Ag Statistics Service, Ohio average cash rental rate change, and this is just the USDA data, and they're going to collect this, and they'll have a average cash rental rate for Ohio, and they'll publish that each year, and there's a percent change, and most of the time there's a slight increase, sometimes there's a slight decrease, but this type of a flex or fixed cash lease arrangement is one where it would automatically adjust based on this predetermined and pre-agreed upon parameters. So it's one that I think has its place in certain situations and between certain tenants and landowners. It's not for everyone, but it is a possibility for some. Okay, so that's an indexed cash lease where it would change from year to year, or maybe every 2 or 3 years, based on how you determine you want that set up. Okay, I'm going to throw one more polling question up here. And it's asking you, what kinds of leases are you interested in? And I guess through my discussion here in the first few slides, I've kind of indicated how I think your thinking out there in terms of the lease types that you're interested in. But I'm curious, so we throw this polling question up here, and for those that have an opportunity, just want to get your feedback. All right, so a flexible, excuse me, a flexible, pardon me. Pardon me. A flexible cash lease. All right, these, you've heard of these in probably many different meetings that you've been in that talk about rental rates and lease types of issues. Flexible cash lease just allows the landowner to share some of the risks without becoming subject to self-employment tax. So essentially, we're keeping this as a type of cash lease. However, there are some flexible components that we build into this lease that will adjust based on, well, however you set it up. It may be based on the way that particular farm performs in terms of yield that year. It might be flexible based on the way that prices move, grain prices. It also may be flexible based on the way certain costs change throughout the year. So I'm going to spend a little bit more time later at the end of my discussion here before I turn it over to Peggy, talking about some of the possibilities and the ways that flexible leases can be set up. Okay, I'm going to end the poll and I'm going to share the results. And a lot of you are interested in fixed cash leases. However, it looks like there's a number that are interested in flex leases and crop share leases. So I'm glad we're going to spend a little bit more time on the flex leases here later on. Okay, economic issues impacting farm leases. One of the biggest questions that we get is asking about what the fixed cash rent should be on a given farm. How do you expect to arrive at an equitable cash rental amount? You know, what's fair? We get that question a lot, not only myself, but also many of my colleagues across the state that work in county extension offices. It's one of the #1 questions that we do get, and we're expected to provide some kind of a thoughtful response. And oftentimes we'll share some data, but don't expect, you know, I've got this picture of me pointing to a certain handout that at a meeting. Don't expect us to have a certain number. And even if we do, I wouldn't feel very comfortable with it because frankly, there are just too many factors at play for us to zero in on one particular number as being the fair cash rental rate for your farm for a given year. We're going to give you some of our insight. We're going to be able to give you and share some of the public data that's available. And I guess probably the best that you should be able to expect in these discussions, whether it's extension educators or myself or other professionals, is some kind of a range. So we're going to talk a little bit more about the data as we go through. We have no public trading exchanges for rental rates. It's not like grain markets where we can look at the Chicago Board of Trade, Chicago Mercantile Exchange numbers and have some kind of an idea as far as a forward or a futures price to give us some guidance. We just don't have that. We do have some public survey data that I'm going to share as we go through this. Occasionally we'll have public bids and solicitations, and oftentimes we'll have these come through our county commissioners on farmland that they may own. And occasionally we'll get those that are published in the local newspaper, and that will create a lot of chatter in a community. And sometimes it will help to set the market, whether or not that's a price that is usable across the whole county or the region. I think that's questionable at times. So how do we determine the rental rate kind of in the real world? And that's the question, you know, that we all struggle with. It's a moving target, and it's based on how, you know, we're looking at the economics of crop production and the margins of profitability in a given period, because that will influence those rental rates. I've got a long list here. I know it's going to be pretty difficult to read for some of you, but I want to tick through some of these things that are going to influence and affect rental rates. Of course, the expected crop return, the number one thing that will affect rental rates. What is the profitability potential on a given farm? And if we know that, and the yield and everything, the expectations, that will give us some guidance and give us some relative idea of what the rental rate should be. And it's all starting with land quality. You know, what's the fertility, what's the land, what are the soils, what are the makeup of that particular farm? That will drive a lot of the ability of that land to earn a rental rate. And then we also look at drainage capabilities. That's an important factor for many. Size and shape of fields, location of fields and access. And then we have some secondary factors and ones that I don't want to minimize. Services provided by the operator. Sometimes those are very important and critical to certain landowners, and they value those even more than the actual cash in some situations. Reputation of the other party is an important piece as well. Then we've got some kind of third tier factors, as I would probably describe them. Previous tillage systems and crops, sometimes those factors in. USDA farm program measurables, those are important for some. The conditions of the lease, the payment dates, the field border characteristics are occasionally a factor. And then, of course, down here at the bottom, very important, what are the local supply and demand factors? And sometimes we get a lot of questions from landowners that aren't really in tune with what's going on in the local community. And sometimes that's easy to understand, as we have lots and lots of absentee landowners, folks that have moved away. But understanding those local supply and demand factors will be an important part of judging what that rental rate should be or could be. All right. So we've got two parties involved in every land rental decision, more than two in some cases, but we'll boil it down to the farmer and the landowner in that kind of a situation. And the problem is that for rental decisions and rental rate discussions, they effectively have opposing views. The landowner wanting to get the highest effective, equitable cash rental rate. The farmer is probably seeking the lowest equitable cash rental rate that's fair. So it's adversarial at its core. So I always recommend folks, educate yourself as much as you can, especially landowners that are a little bit more removed from the production aspect of the farm. This is a valuable asset. Farmland has only gotten more valuable over the last couple of years, and farmland is a very hot market right now. But make sure that you have a good understanding of all of the different aspects of that asset. Understanding of the land quality and the production capabilities, crop economics, those are important first steps. How does the farm rank in terms of quality and production? What kind of soils do you have? What kind of drainage capabilities? And then we'll spend some time here in a moment talking about the economics and what are those, how do those change from year to year and impact rental rates. So, okay, soils. I'm not an agronomist. I'm not a soils scientist, but there is some data out there, and every county has a soil survey that you can go and you can get those somewhere in your county. Oftentimes it's at your local soil and water conservation district. Some extension offices carry those as well, but it's not what I'm showing here on this slide. This is a second piece, but a good soil survey from the county, even those are very dated. Those were done, many of them back in the 60s and 70s and 80s, as I recollect. But it will give you a little bit better idea as far as the soils on your farm, if you don't already have a good understanding. And then this old pub that I'm showing here, this is Ohio Soils with Yield Data and Productivity Index. So most of this is very dated information, but it will give you a relative idea as far as the soils on your farm and what the productivity index is. So an index, in this case, it's based on 100 being the highest, and then tiering everything down based on the productivity potential. The yields that are listed in this bulletin are 50 years old, so they're not going to be applicable to any discussion these days. But you can see I pulled out a few and magnified them here on the right-hand side. This is, it's 40, 50 pages long, identifying all the soils in Ohio. And it will tell you if you have, looking at your own soil survey in your county, that you're going to look at your soil series and then look at the productivity index. And the higher the number, the more potential productivity that particular soil is supposed to have. This is not going to be a perfect analysis, but it will give you, especially if you're unsure about where you're starting from, this will give you an idea as far as the productivity of a particular farm that you might be looking at. Of course, there is more discussion these days, and even some of the landowners that I've had discussions with will require yield sharing. Now, lots and lots of farmers are uncomfortable with that, so it's a discussion that might take a little bit of time. So that's something that is often tricky, but it's one thing that as a landowner, you can add stipulations into your lease. Probably will get in trouble for saying that, but I don't think that's news. And I think many farmers are aware that some landowners are seeking more information in terms of the annual production cycle. All right, so from a purely economic perspective, if I'm just talking about what the rent should be as an economist, it should be almost equal to the return to land, or it should be equal to the return to land. So what is the return to land, do you ask? Maybe you're not asking it, but I'm going to tell you anyway. Okay, so we're going to go through these calculations and I'll show you how we arrive at returns to land. And it's just a process where we're looking at a budget. We're looking at a budget for all the costs and all the revenue potential. And then what we have as a residual, that's going to give us an idea as far as what that return to land is. Okay, so let's take a look. And one of the things that I want to present is a picture for this upcoming year. And we're going to see, and we are already seeing much higher input costs. So farmers are going to have to deal with higher input costs in this production year. Fertilizer in particular, much higher costs, energy, seed, somewhat higher, crop protection chemicals. And that's something we really don't normally have to discuss too much. But with many of the COVID-related supply chain restrictions, we're seeing some of those products selling at a premium, 200-300% higher than where they might have been last spring. So you can see a number of these costs, and the whole cost structure is increasing for producing commodity crops this year. So we kind of look at each crop. This is the corn budget as we're looking at it here within the last couple of days. The prices are still high, so that is going to give us the potential for some profitability. All of these things are a work in progress. They're all moving targets, including the price of corn and all of the costs. But the returns to land, not as favorable, our outlook is not as favorable this year as what we ended last year on. The returns would have been more favorable in 21 than what it looks like we're looking for in 22. So the corn crop, this is an acre of corn. The return to land somewhere around 173 on average, assuming this 183 bushel production is the 20-year trend yield for Ohio. Okay, soybeans look a little bit better in terms of bottom line, 13.80 a bushel, and this is of course subject to change as we go through the growing season. 57 bushel beans, returns to land much more favorable. Wheat, we look at wheat. It's the third place crop in terms of profitability outlook. This, of course, is already in the ground for those that are raising wheat. 73 bushel trend line wheat, $162 return to land, 750 wheat. We compare them all, and you can see soybeans, at least right now, seem to have a little bit of an edge, and some, of course, would have a different cost structure in place compared to what we're showing, and are going to have a number of things different as far as the bottom line. But you can see there's going to be a mixed bag in terms of returns to land as we look across the three different crops. But overall, I think we're going to see less profit margin potential in 22, and much of that's going to be based on these higher costs. Okay, let's look at some of the statistics that are out there. And some of these you're going to be aware of, but we're going to focus on them again anyway. The National Ag Statistics Service, which is a branch of the USDA, they conduct a survey almost every year, depending on whether or not they have the funds, but they have the last couple of years surveyed Ohio farmers to determine what are the average cash rental rates in each county. So they're able to publish an average for each county, and you can see right here in front of us, I'm over here and here's Franklin County. This is where I work, $193 per acre average cash rent. And you can see if you want to look now, some of this on some of your screens might not be big enough for you to see. If you want to find this, you can find it real easy. You can do a web search. You can do a Google search for NAS Ohio, and that's going to take you to their website, NAS Ohio, and then you're going to go into the county estimates, and that the county-based data will eventually allow you to get to this particular page and see this data. So this is a really good starting point. I recommend using this data, and at least there's one of the pieces as you try to evaluate not only what the rental change might be, but also kind of a baseline of rental rate for your particular farm. Now, there's going to be farms in each county that are going to be above and below this average, of course. All right, but they showed about a 2.6% increase in cash rental rates from 20 to 21. Our data, and I've got all of the different regions in this slide set, and I'm going to show a couple of them, and then I'm going to show the others very quickly. If you want to look at the data, you can go into the slides, the PDF of the slides. It's going to be available on this particular webinar's web page, resource page. So our survey, we conduct this in the winter each year, and it showed around a 3.5% to 4% increase in cash rental rates for Western Ohio. And I've got some of the other data here as well, but this shows Southwest Ohio, and we also ask and we get feedback based on tiers of productivity. So it's just not an average. We ask for, what's the average cash rent on average land, and then on top land and poor land. So average land in this particular region, according to the survey respondents, is land that would produce 182.4 bushel of corn. And the rental rate would have gone from 207 in 20 to 215 in 21 on average in this region. And we realize it's not going to be the same from one end to the other. Delaware County is not going to be the same as Darke County. There's going to be some range even amongst average farmland. So make sure as you're looking at the data that you're also understanding that we have some pretty wide ranges here. So top ground, of course, is going to rent for a higher rate on average. And there's going to be outliers that we're not capturing even with the range. We know that there's some average land in this region that probably will rent for lower than 179. And on the other hand, we know that there's some average land in this region that will rent for above 252. Now, the other thing that I want to point out is that we're not considering these categories to be a third, and a third. When I evaluate this data and I talk to some of the respondents, we can probably lump in about 10 to 15% across this region as top land. And then a large majority, probably 2/3 of the land, would fall somewhere in this average category. And then the rest, the residual, would be poor land. So it's not a third, and a third as I think about how land falls in each of these particular productivity classes. Okay, so that's this is normally the highest land value and highest rental region in the state. This is the next highest, and this is Northwest Ohio. Pretty similar in terms of productivity, but typically a little bit lower rental rate on average. And you can see there. Now we've got some other data also from some other regions, and we look at the Federal Reserve Bank of Chicago. they survey and publish information each April and April 1st, and they showed from April 1 to April 1 of 2021, a 4% increase in that particular Fed district. That includes the northern 2/3 of Indiana, Illinois, all of Iowa, parts of Wisconsin and Michigan. So it's not Ohio data, but it's right next door. So it can also give us some feedback as far as rental rate direction. The Purdue report right next door in Indiana showed increases in the Indiana farmland values of around 3.5% to 4.6%, depending on the productivity. So pretty similar to what we were finding here in Ohio in terms of rental rate increases. Now I've got some other regions. Now I want to caution you in terms of using the data from these other regions because of the relative lack of data. We had much less response rate from these regions. And that's one of the reasons why we're not publishing this in any kind of bulletin at this point or fact sheet. But I am making it available here. I just want to caution you again, though. It's for, I guess, informational purposes. I guess it's all for informational purposes, but I want to caution you, especially in using data from these other regions, because in some of these regions, we only had 5 to 10 data points to work from. So very low number of data, and it may make it unreliable. We think it's close, but it's something to use with some caution. So this is southern region, then we have this north central region, if you will, and all of this data. I'm not going to spend a whole lot of time on this, but I want to show you the different regions. And then we've got this far northeast corner of the state that has a little bit different market for rental rates. Then this region on the kind of the border over here, some of these counties do overlap because they have characteristics that are similar to a region in parts of the county or similar to another region. So that's why they may be included in two. Trumbull County is one of those. But you can see the rental markets are much lower. And this particular last region, not a lot of land that's rented other than, we see a lot of pasture land rented, not a lot of row crop land that's rented. And that's what we're looking at here is the rental rate for row crop ground. And some of these regions, they're going to have exceptional soils, and you're going to be only seeing those in perhaps river valleys, and but they're going to be renting for much higher than maybe what we're seeing here in this data. But that just shows you some of these other data in regions.
Hey,
The rental
Barry,
rate outlook, yeah.
there's a question in the chat box about where the data came from and whether you sent out surveys for that.
Oh, yes. Okay. Yeah. This data is collected from a subset of folks around Ohio. These are mainly targeted to ag lenders throughout the state and our professional farm managers and rural appraisers. This is not a farmer or a landowner survey. So we're surveying third-party professionals. It's a good question. Okay. Thanks, Peggy. All right, as far as outlook, we're looking at a number of things being supportive of rental rates, the income increases in the last 2 or 3 years, a lot of ad hoc government program payments that have been paid out over the last few years. The one big driver and the one big supportive piece that I'll point out in particular is net worth continuing to improve in the sector. So we're seeing this as a real positive, even as we go forward into 22 with some of these higher input costs. And that's what I think will affect rental rates as we go into 22. We may not see the giant increases in rental rates that we might have expected with 550 corn or 1350 soybeans, simply because farmers are going to be dealing with these much higher input costs in association with these higher crop prices. Expecting to see a rental rate increase, maybe in the neighborhood of 5% or even higher in some regions, simply because, we've got some of the spillover in net income and these more improved net worth. Okay, some general comments. The short-term high margin period is going to create long-term cost structures that may be unsustainable. Rents may be established that may be unsustainable in the long run. Landlords, have to understand the value of non-cash benefits. Farmers as negotiators, making sure that they understand their balance sheet, net worth, stress testing that balance sheet and cash flow. Cash rent bonuses might be a good alternative in this environment, and flex leases likely should be considered. And I'm going to speak just a few minutes here on flex leases as I start to wrap things up. We can flex and set up a flex lease on a number of parameters. Typically, they're set up on some kind of revenue, the way yield or price moves throughout the production period. And I've got a few examples. A cash lease with a bonus approach. This might be one in this environment that might be appealing. But we still have to negotiate a few things, what the base rent is, what the base gross revenue is, how to calculate and verify between the two parties, what the yields and prices are going to be that are going to go into the formula, and how we share and what percent of that any revenue above the base. So here's an example of what that might look like. We set up a base, we negotiate this, we negotiate a base revenue, and then we have to negotiate, okay, anything above that, we're going to share 33% back to the landowner. Here are the calculations. I'm not going to spend time dwelling on this too much, but this is one particular type of flex lease that's often used. The more common one, and probably the most common flex lease that's used in this part of the Corn Belt, is the percent of gross revenue, where we again have to negotiate a few factors. Here's an example. We're going to establish a base rent, and then we're going to negotiate what percent of that base gross revenue is going to be shared in part of the rent back to the landowner. There's some numbers that I've laid out there. These are oftentimes just as difficult to negotiate as a fixed cash lease. So it may not alleviate all of the consternation with the back and forth. Percent of net income approach. This may be a little bit more equitable in this environment that we're in right now, primarily because we have a much higher cost structure that we're dealing with. So it will require a lot more sharing back and forth between, especially the producer, sharing information on costs with the landowner. But it can be it's a reversion back to a crop share lease as we're sharing all of this information, and it will look very similar to a crop share lease in the end. All right, here's a survey that we did a number of years ago, just asking people their actual setup for their own flex leases. So there's several examples that I'm pointing out here, and it just shows you that there are different ways that they can be set up in terms of sharing a percent of gross revenue, or in some cases, we're looking at a bonus in this case where we're giving a bonus of $20 if corn is above a certain price. So we do see those on occasion. So that's just a few examples, and just point out that flex leases may be a tool that you could use. There's a good website, and I'll let perhaps Peggy and Robert also weigh in on the pros and cons of using sample leases. And this Ag Lease 101, this is a joint project by the states in the North Central region, the North Central Farm Management Extension Committee, which I've been a member of for a number of years. And the bulletins and the accompanying sample lease forms are only a starting point, and they shouldn't be used as the final lease. That should be something that should be considered with your attorney. So with that particular segue, I'm going to turn it over to Peggy, and I think it's time to switch topics. And I want to thank you all for your attention. I'm going to try to get to some of these questions. I know I didn't get to all of those as we were going through this evening, but I'll try to get to some of these as I turn it over to Peggy. Okay, it's all yours. And I am not seeing your slides.
Sure. I think something's wrong here with my share. Let me try again.
Okay.
There were a couple other questions, and I was trying to get to those. If you want to take a minute there. Barry, in the
Sure.
Q&A box, there's a couple.
Oh, yeah. Okay. So one of the questions is on, are there any numbers available for pasture land and barn structure leasing? Well, the second question is very little on any kind of livestock buildings, barns, et cetera. That data, we last collected that as a North Central region back in 2014. That summary is available at the Ag Lease 101 website, so you can find that there. But the reason that there's just so little data out there in terms of barn leasing and livestock facility leasing is there's fewer and fewer people that are doing it, and a much smaller pool that we can survey from. Now, there is one piece of data in our last custom rate survey as far as lease amounts per square foot of storage space. So that might be helpful. But outside of that, no. Pasture land, yes. The NAS Ohio data, you can find some rental rates on a county by county basis, just like I showed for row crops, but not every county, but you can find that. And also on our survey, especially for the two regions, the Southwest or the West Central and the Northwest, we also have an average pasture rental rate there. So yes, that some of that data is available, some is not readily available. Yeah, as a farmer, I found it improves. Yeah, and some farmers are readily sharing some of the production data and also some of the fertility data. And so I think that builds a stronger relationship. So I think that's answering those two questions, and I'll keep an eye out for more. And you
Okay,
look good to go.
Good.
And
Now it's showing.
It is. And you let me know when you want me to launch this poll.
Okay. For some reason, I can't see. Typically, you can see the green box to know for sure which screen you're sharing, but it's not.
You're
it's
on
not
the Ag
showing
Lease
me.
101 page.
Good.
So
All right, we're good to go then.
yeah.
And hi, everybody. And thanks again for joining us tonight. I'm Peggy Hall, as Barry already introduced, and I recognize many of you. So hopefully I have talked with you before about this issue of leasing. So Robert and I are going to offer some thoughts on some of the legal issues that we're seeing in farmland leasing. And I want to start out with a little hypothetical for you. We're both teaching the ag law class down at OSU, so we're very much in hypothetical mode these days, aren't we, Robert? But here's a hypothetical for you. Where you have a tenant who's been leasing land for quite a while from a landowner, just on a handshake. And that's not uncommon still across Ohio. There's no written lease. Every January, they talk about what the rent will be. And then the tenant always gives landowner half their rent in March and half in November. Pretty typical arrangement, right, Robert? So let's say that landowner passes away in March. And the heirs put the land up for sale. Should tenant proceed with planting? And that's one, I guess I should have done a poll question to see what you all think about that, what your answer would be to that question. If you were the tenant, would you proceed with planting for the year? Would you feel that you're a little vulnerable since the land is now up for sale? If you're those heirs, do you feel you have the right to just sell the land and regardless of this leasing arrangement that's been going on for quite a few years? You want to answer that one, Robert?
Well, like most legal answers, it depends. But yeah, it does put the tenant in a tough spot, because how long do you wait? And if the heirs are wanting to sell, they may not much care what the tenant wants. So the number one lease call that we get in private practice is this kind of scenario
Yep.
Got a verbal lease. It's about this time of year. Something happens. Do we have a lease or not? Do I plant or not? So
Exactly.
it's a tough spot. The answer is get it in writing, right?
That's where I'm headed with this.
Mhm.
But you've said when you were in private practice, that's an issue you dealt with all the time. And here at OSU, it's a question I've answered over and over, and many times have referred people to go see attorneys like Robert, because there is a lot of uncertainty in this situation. And the big question is there a valid lease that's enforceable or not? But
And
let me tell you, part of the
Peg-
answer, yes.
Peggy, I was just going to mention it, and the reason that we can't give our audience an answer is because there is not a law that says, here's what the law is in this situation. Now that I think that's changing, but the law in Ohio is unsettled. I don't know what the right word is. Really,
Yeah.
there really isn't much of a law that says, here's what happens in this situation.
Yeah, I think I would describe the state of the law in Ohio as we have a law that addresses that, but there's a gray area and there's an opportunity to try to use that gray area and create an exception to that law if the facts are in place that would allow you to do that. And so that's why I often end up referring those questions to someone who could do litigation if necessary. And that's certainly not where we want to see these issues end up. But the law that I'm referring to is the Statute of Frauds. That is a law in the Ohio Revised Code, as you see here. And it says that, a lease or an interest, any kind of transfer of an interest in land, Ohio law requires to be in writing and signed if you want to enforce it against that other party. So in this situation, if the tenant wants to enforce what he believes to be a contract, because it's a contract that deals with an interest in land, a lease, then Ohio law says, well, you need that contract to be in writing, and that landowner should have signed it if you want to be able to enforce it now. And that's the law. That's the law that we do have that is black and white. But the gray comes through the many, many cases that we've had where a court will enforce a verbal contract for an interest in land, not as much for a sale of land, but for lease situations, we have more case law that deals with that issue. And the courts will say, well, we might allow you an opportunity to come forth and prove that we should set this statute of frauds aside, just ignore it and allow you to go ahead and try to enforce this contract that was verbal, even though the law says it should have been in writing. But that's a heavy duty, isn't it, Robert, upon that person who wants to try to enforce it? You're going to have quite a burden of proving why they should ignore what the law says and enforce your contract. And typically where we would see an enforcement would be if there are issues of equity. So could you see an issue of equity in the situation that I just described? Would it be unfair not to hold up that lease at least for another year? Would it be unfair to hold it up and allow that tenant operator to go ahead and farm it for another year? We kind of have to balance equity in many of these situations, but that person who wants to prove that, hey, there is a lease here, and in the hypothetical, that would be the tenant, would have to go to that court and convince the court to make that exception that that lease should be enforced, even though it wasn't in writing, and then would also have the burden of proving what the terms were of that verbal agreement. Any thoughts on any of that, Robert?
I feel like it's an uphill battle. A judge is, and this isn't disparaging towards judges, but judges want to find the easiest solution. And if the easiest solution is just kind of following the law and say it's a verbal contract, we don't have a contract, I think that will happen more than the tenant saying, but I've done tillage, I've already sold the grain, it's not fair if I don't get this lease. I think that's the harder argument. Not that it shouldn't be made, and not that it's not a winning argument, but I would say it's the harder argument, less likely to win argument.
And it's going to cost some money to be exceptionally persuasive in that argument and proving that. There's a question here in the case of a lease that's a term of years. So let's say it's 5 years and the landowner passes away in year 1. Are the heirs responsible in that case for continuing out the rest of that lease? And it's a written lease. So now we have a lot better situation to deal with, right? And the answer to that is still, though, it depends.
It does depend. This is where what is in the lease matters a lot. If there's a very simple phrase that says this lease is binding on the heirs and successors, something like that, then you've probably got a 5-year lease regardless of who the owner is. But if the lease is silent on that point, now we're back to, I don't know for sure. It
Right.
depends again. Yeah.
Right.
Mm-hmm.
Slightly different issue where we actually have a written lease, at least to enforce, but missing an important term.
Right. Peggy, there's a comment in the chat. Let's see, where was that? Sorry. A common fear for our farm, we have many landowners we lease from over the age of 80. Is this, I'm just wondering if you wanted to address that.
I think that is why, as I think back through all the calls and emails I've received on this issue, it has typically revolved around an elderly landowner passing away in that long time relationship being subject to change. I would say that's the norm. I don't have the actual numbers on that, but I would say that's the norm. Is that your experience as well in private practice?
Right.
Yeah. So let's talk then about what we can do to avoid some of these uncertainties and problems that we see in that leasing arrangement. We want to make sure that we can, address that risk of this kind of situation happening. Some additional risks, in addition to what we just talked about in the hypothetical, is we do have uncertainty just all around this leasing situation. We don't know when it legally begins and ends. We don't know, as someone already raised with a written lease, this can be in a verbal situation too. Is it binding on those heirs and successors? We don't even know how to terminate a verbal lease because we haven't addressed those issues in that leasing arrangement and how much notice of termination is given. And that is where the most case law exists, right there in that last bullet. Did in a verbal leasing situation that someone's trying to enforce, sometimes the argument is they terminated too late. They can't terminate at this point. They didn't give me notice of termination, and now I have invested all these costs in this leasing arrangement. And so it will be unfair to terminate at this point. So a lot of it gets to that issue of providing satisfactory notice that, okay, we're going to end this relationship. The most recent case that we have on that issue, an elderly woman tried to end a leasing arrangement, a verbal leasing arrangement in March. So that is pretty late. And the court said, no, that's too late. Yes, it's a verbal lease, but he's proven that it does exist. He's proven all these investments he's made in this arrangement. And here you are now, a month or a month and a half somewhere, in planting, we're right up at planting season and you want to terminate it. And that is too late. And that gets to that issue of notice of termination. And that's something you would address in a written lease, right, Robert? Notice of termination.
Sure.
When do you have to notify that other party that the leasing arrangement's going to end? Well, we have legislation currently in our General Assembly that gets to this issue of notice of termination. We're one of the few states in the Midwest that does not have a statutory notice of termination provision. And so this bill would change that and would codify an arrangement in the event that the lease doesn't address notice of termination. So for any crop lease that doesn't say when notice of termination must be given, this would be the default rule that we would look to. And so of course, in a verbal leasing arrangement, it's very likely that there has not been any discussion anything that one party could prove, this is the term we agreed to on notice of termination. So this would certainly step into those verbal leasing situations, but it could also apply to a written lease where that has not been addressed in the lease. So in that case where they have not addressed notice of termination, the law would say, and remember, this is not effective yet, but it would say that a landlord, it's going to put the responsibility on a landlord who wants to terminate a lease that doesn't address notice of termination. That landlord must give a written notice of termination by September 1st of that lease period. So in the example I gave where the elderly woman terminated in March, or in the hypothetical where it appears the heirs could be stepping in and terminating by putting the land up for sale, those would both be past that September deadline. And so it's too late, according to this proposal, to terminate that lease at that point, and it would have to be allowed to go on for another period. So that written notice by September 1st, as I said, applies only to landlords. There's nothing in the law about a tenant's duty to notify the landlord of termination at a certain time. If the landlord does give that written notice, then the termination date would either be when harvest is complete or the end of the calendar year, December 31st of that year when the notice was given, whichever one comes first. That signifies the end of that leasing arrangement. So this proposal did pass the House of Representatives in December, and it just yesterday had its first hearing over on the Senate side. It's before the Ag and Natural Resources Committee now. In the Senate side, the first hearing, it was just the sponsors giving their testimony on the bill. So we expect several more hearings on this bill on the Senate side before we know whether this one will go through. Any thoughts on that, Robert, or questions?
I was gonna, couple thoughts. One is I do think the law probably favors tenants a little bit more, just because it is the burden of the landowner to do it, and it's a fairly early date. But I think it's good for both tenants and landlords to have this. I was going to also say, for those landlords we have that, maybe you're not real familiar with crop production and you're like, why is it September 1st? Why is it so early? Why isn't it March 1st? A lot of farmers start buying inputs for the following year in September. And then also wheat is planted the beginning of October through October. So those are probably the two biggest reasons that it is, a termination date, 6 months, 7 months before the first seed would go into the ground.
But stopping the tenant from making those additional investments if
Yeah.
the lease isn't going to continue
Right.
for another period.
Right.
There's another question here, going back to the hypothetical about the landowner accepting money. If the landowner has accepted money, does that make that verbal situation binding or change the dynamics? And that could be one of those offers that we would put forth to say, this is why it would not be equitable to I've paid my money, so let's enforce this lease. It would be unfair. So yes, that would be an important factor. Okay, so if that goes through, that will change what's happening out there around Ohio. And maybe this would be a good time right now, Barry, to do that poll on written versus verbal leases and get a sense for what is happening. Barry and I have asked this question before in our previous workshops, and it's been hovering around 50%. Verbal versus written, and we saw a slight uptick, and I would say right now we're seeing more than a slight uptick. As I see the results coming in on this, we'll share them with all of you in a moment here, but it's always hovering right around that 50%, half and half written, half verbal. Even though I've been out there giving my lectures about you need to get your lease in writing so we don't run into these problems. Are we seeing a shift in that. Are you ready to go ahead and show it, Barry?
I can. We've
Poll
got a few
results?
people
Got a
that
few more. So
have
we're
not
asking,
responded.
yeah, asking, do you use written leases, verbal, or both? I know in some situations, it's very difficult to move from a verbal handshake arrangement to a written lease. And I have some thoughts that I offer in a law bulletin on farmoffice.osu.edu on how to make that conversion from verbal to written. You can take a third party, a private practitioner, as Robert has been, and kind of let them handle that. Blame it on them. You know, it's my attorney's fault. They want me to put this in writing. My accountant wants it in writing. Blame it on someone else. I find that to be a good way to go about that. But let's see.
There's
Are
the
you sharing now?
results. Yeah.
Okay. So it does. Look like we're still hovering around 50% for written. But we've got some that are half and half. So it'll be curious to see. In our evaluation, we do ask with a little more detail you to tell us a little bit more about those leases. It's something that we're very interested in seeing. And certainly with this law change that may be coming, we may have some verbal leasing situations that may want to make the conversion then so that they can set their own termination provisions and notice provisions, because if they don't, this law will step in and do that for them. Okay, so let's go on and think about, as I said, some of the risk that we see from that verbal situation can be addressed by putting that lease in writing. And there are many, many forms out there, many fill in the blank forms. Some of them are good, but some are not really very descriptive or detailed. And so I wouldn't discourage you from looking at those, but sometimes we don't know who wrote it. We don't know where it is coming from. We don't know what state laws it's written for. And so I would encourage you to use it just as a source of information, maybe as an example, maybe mark it up and then go to your attorney. Or if you have a good ag attorney, my guess is that ag attorney already has a pretty solid lease that they can take and adapt to your situation, tailor it to your needs, and that's not going to cost very much, right? Would you agree with that, Robert?
I would agree with that.
It's not a major cost, especially if you have an attorney who knows what they're doing, they're familiar with farm leases, and they'll make sure that lease is consistent with Ohio law. So go ahead and look at those forms that are out there and consider those, but some legal review is certainly something that I recommend in that situation. We have a law bulletin that provides a checklist of terms to include in that lease. And then, as Barry mentioned, the Ag Lease 101 site, also on our farm office site, a lot of resources that explain leases. Ag Lease 101 even does have examples of leases that you can draw from. So use those resources. But let's talk a little bit more about those lease terms, just a review. When we think about, we want this lease situation to be enforceable, part of that task is to make sure you have terms in there that address the situations that commonly come up and can create issues in a farm lease arrangement. So we want to have those common terms in there in that written lease. And so these are very basic terms that we would see in just about any kind of contract. We have to identify those parties and the land and the property and have their signatures. You would expect that. And then we also, of course, get to a lot of farm leases, that payment part is right up front. It's about the first section you come to after we identify the parties. So we want to address in that lease the rental amount and the payment dates, whether there are penalties if there's a late payment, how you submit those rental payments, and if there's going to be a security. for that landowner to secure those rental payments. Those are very common provisions and certainly some that we would like to see addressed. And Robert, if you have commentary on any of these, please jump in as you see fit.
I do. So it may seem like an obvious, well, of course you identify the party. But when I'm working on a lease for the client, I go to the auditor's site and I look that parcel up, and you'd be surprised how much land is sitting in trusts. And the landowner forgets, oh, that is in my trust. It's not in my name personally. And a trust is different under the law than the person. So if you're the tenant, look that parcel up and verify the owner. Make sure it's not an entity, make sure it's not in a trust. And as landowner to be familiar with how you own the land. Is it in a trust entity, your name? Is it in multiple people's names? So the identification of parties can be a little trickier than what you might think.
Good. And when we look at the payment and the rental amount, that would tie into many of the different options that Barry explained for what type of lease we're going to have. And so those provisions can be pretty detailed depending upon what type of lease you have. And there are many scenarios that we could go through there. So it's not as simple as just to fill in the blank, here's the rental amount for many of our leases. That certainly has changed and varied over the years. The time, go ahead.
Just kind of, the more definitive you can be as well. I see leases that will say $200 per tillable acre. Well, whose tillable acres? Your tillable acres, the auditor, FSA. I like to have, if you want to put the rent per acre, that's fine as kind of a baseline. But I like to have, here is the exact amount owed to the penny in bold, so there is no misunderstanding how much the rent is. Something very easy to take care of up front, but if you don't take care of it, it can lead to some misunderstandings pretty quickly.
Right. So Robert, you're just perfectly illustrating the value that an attorney can provide as you're going over your lease and putting it in writing.
If I can't, I've got problems because I've been doing it for the last 20 years. So.
Right. So up here on the right-hand side, we have the time period of the lease. And we see a range of those. We've asked that question in the past, and many of them are year-to-year arrangement, but we do see some that are 3, 5. I think, Robert, you've even had some that are 10 years. But we want to make sure we clarify when's it start and when does it end, and are there rights of renewal? We could set up a situation that says it starts now and it's going to renew automatically every year unless one party takes action to terminate it. That's a very common situation that we see with farm leases. So it'll just automatically tick over unless somebody terminates it. And that's why the termination is important too. So when does it terminate? When do I have to give that notice? Because if I don't, then it's automatically flipped over into another lease period. You can have some provisions that force a sit down if it is more than a year or before it would flip over into a new year. Maybe you want to sit down and review the lease and the rental amount prior to that incident occurring where it renews. Some general provisions for how are we going to amend or alter this lease. And we do see sometimes changes that need to come in. For example, if we decide we want to make some capital improvements and put in some drainage, we can write an amendment to that lease and address how those capital improvements would be paid. We don't have to start over with a new lease. We can just amend that lease and amend those terms. And then a very common provision, and you'll understand this one better in a moment when I explain the memorandum of lease, is that the parties agree that they will also sign a memorandum of lease. There are those kind of basic issues that we see in a lot of property contracts where who has rights to do what, can you enter the property when, what happens if we transfer the property, What if there's eminent domain, those kinds of provisions, just put them in there and have that certainty. And there's a provision, as you see with the issue we've talked about before, on, what effect does this have on heirs and successors to the current landowner. Another common provision, participation in government programs, how that will happen, landowners' consent, tenants' right to participate, those kinds of provisions, as well as who's responsible for ensuring the property and the activities on the property. And then sometimes, as Barry mentioned, we may see some provisions where the landowner may want the tenant to document yields to provide that data over to the landowner. Any comments on any of those, Robert?
Yeah, so these are all great terms, but I would also say, as attorneys, if we could kind of have it our way and we didn't have to worry about your business dealings and your personal relationships, we'd give you a 10-page lease with every possible provision in it we could think of. But when I talk to clients, I also tell them, look, you got to be able to deal with the other person. If you hand your landlord a 10-page lease, they're going to be like, get out of here. I don't have time to read this. So, if some of these terms aren't in your lease, don't panic. That's okay. I've worked on many leases where we kind of just made it bare bones because that works best for the relationship you have with your tenant or landlord. So we're kind of giving you all the whistles and bells. You need to kind of decide what's important to you. What's the best lease for your relationship?
Right,
I just
good.
wanted to point that out.
Yeah, and in that law bulletin I mentioned, I talk about that maybe you have an intermediate step where you just go to a simple lease, and then as you become more comfortable with that, you could add some terms later. You don't have to start with all of this if that's going to dissuade getting something in writing. Especially, we would hope that you would go to a simple lease and get it in writing at least, and get some of those really basic terms, and then work from there. We could have some maintenance and improvement provisions as well. So who's responsible for, the field access points, or for maintaining drainage, or sometimes especially where we have animals involved, who's going to take care of the fences, who's going to clear the fence row, those kinds of provisions. And then also, if there are repairs, how are we going to deal with repair costs? Who bears those costs? And then, as I said before, procedures for capital improvements can be something where we at least have a process in place, and then could amend with the details of that process later. As far as farm operation terms, you could here have a little more discussion and agreement on how we're going to actually operate the activities on that land. And so some practices that are prohibited, who's responsible for noxious weeds, if there is that process that comes into play. What about soil health and fertility, conservation practices? I'll talk a little bit more about these kinds of provisions. One I see regularly, Robert, is the hunting and recreation uses by the tenant there. And also for many of our absentee landowners, I see provisions for the tenant being responsible for kind of maintaining the property in their absence while they're gone. Any thoughts on any of those provisions?
Hunting rights should be addressed. If they're not addressed, I really don't think typically hunting leases would be included in a cash farm lease or any kind of farm lease. But it's good to address it because the tenant may have a history with other landowners of, sure, you can lease anytime you want. So hunting leases should be addressed, whether they are included or not.
Good.
Mowing is a big one too. Many landowners, for the tenants, many tenants kind of get bonus points for doing some mowing. And if you're a landowner, and especially if you're an absentee landowner, don't hesitate to ask in your negotiations for the tenant to do some mowing for you. They probably do it on other farms already. So, that can be part of the negotiations.
Mhm.
And I'd say mowing ditches, driveways, that sort of thing.
Okay. So the last section, the last types of terms to consider adding would be those that deal with termination and disputes. And as Robert said, a lot of these you don't have to have. It's up to you, but this one I really think you do have to have, and that is the notice of termination provision. If you don't have it in there, remember, if this law becomes effective in Ohio, then it's going to stand in and provide your notice of termination provision for you. But you can agree on, okay, if either one of us wants to terminate, what is that deadline for notifying the other party of termination? And what's the process? How do we go about it? Can we just text them, leave a voicemail? Does it have to be written? Where is it to be delivered? Those kinds of provisions. And that will dispense with many of those issues that we've seen with termination and notice of termination. If there is some activity that has occurred, we may need to address reimbursement for costs for benefits to that landowner if that lease terminates. So there could be some reimbursement provisions for nutrients and field work, depending again on the situation, when it started, the lease started and ended, what the baseline was when we began, whether there are benefits to the landowner that the tenant has provided that have not been fairly addressed. So that can be a little bit of a tricky provision to include. Also acts that, let's say if you do this, that's a default of the lease. So we know we're now in a breach situation. Or if there are problems, how are we going to resolve those? How you notify me of a problem? How do we resolve those disputes? And what is our process for resolving those disputes? Okay, additional thoughts, Robert?
No, we've got some comments and a question though.
Okay.
There was a comment about why is so much land held in trust. I'll address that in my section a little bit later. Applies a little bit to what I'm talking about, but it's a good question. So, Edward, you're going to have to help me out on this. What about the use of sludge? ORMA.
Oh, I bet it means or manure. I think he was probably trying to or manure.
Okay. Yep. And then we got a comment. We have several landlords that we've farmed for 40 years, and a long detailed lease would not go over in a favorable manner.
Good.
That's
so there's an
absolutely
example
right.
where, yeah, let's just start with something simple. And at least get it in writing and address what we see as the primary problem with a verbal lease. And that is this issue of termination. Can it be terminated? Is it binding on those heirs? When should notice be given? We at least want to get those provisions down.
But on the sludge or manure, if you don't want it if you're the landowner and you don't want it on your property, just simply put it in the trust. No manure or sludge, and that takes care of it.
In the lease, you mean? You said in the trust. I think you meant in the lease.
See, I get trust on my mind. Put it in the lease if you're the tenant, and that's a big part of what you do is, using manure for your, fertilizer program. Make sure it's in there. So,
that would be over there under the farm operation, prohibited practices, or what I've seen too is if you'll allow animal manure but not sludge, it has to be done in accordance with a nutrient management plan that's been approved by SWCD or a similar organization. So that can be dealt with, and that's not uncommon to see that in a lease.
Our question is, can you clarify what acknowledgement of signature is? Is this a witness or a notary?
Okay, I'll be talking about those steps to lease enforceability, and I'll answer that. That's coming up pretty quickly. So we do have an answer for that. Before we get to that step of finalizing and making sure that your lease is enforceable, I want to talk a little bit about some of those conservation practices that could be in that leasing arrangement. And we've seen a lot of interest in this this area in recent years, which is why I thought it important to bring it up tonight in the webinar. But I want to share with you too these quotes that I found from Iowa just not too long ago, 2001, 2005. And I think they illustrate sometimes we talked about how it can be difficult to get a lease from verbal into writing. It can also be difficult to discuss some of these conservation practices, or even, as someone already asked, what if I don't like sludge and I don't want my operator putting sludge on my land? Those kinds of needs or demands or desires when it comes to conservation or how they're operating and managing that land and the soil, those can be really tricky to navigate. And so whether you're on one side or another, sometimes there are going to be some issues to deal with if you want to include some of those kinds of provisions. And you see from these quotes, one tenant where the landowner was reacting negatively to the tenant bringing up what he was referring to as kind of, conservation practices. And then on the right, you have a situation where the tenant's feeling like, well, why would I want to do what the landowner wants me to do in regards to those kinds of practices? It's not my land. Why should I put all this labor and sweat equity into, doing these practices that end up increasing the value of his property and his land? Those are some of the sentiments that I think we do encounter when we talk about this issue. And so I just wanted to highlight how important it is to try to at least get both sides on board when we talk about some of these issues. And those may be difficult conversations to have, but just recognize that there could be some of these somewhat traditional reactions and emotions to what is the way that we're going to actually farm this land. What practices will we use or not use? And what additional conservation practices and programs do we want to engage in? So when I use that term conservation practices, I'm including both what is traditional long ago, when no-till was the big new thing, and that was the big new conservation practice, and that was intended to address runoff and erosion and soil loss. We have those kind of traditional conservation practices out there, and some that are newer. And so I would define conservation practices as these kinds of things that address soil health or drainage or runoff, erosion, even wildlife habitat. We have some leases where the goal is to provide wildlife habitat, improving water quality, a lot going on in that area, as well as carbon capture. That is certainly a new conservation practice that we may need to consider in the leasing arrangement. But there are challenges to adopting these kinds of practices, and many of them are challenges that the tenant operator faces, but some are the landowner as well. A tenant could be dealing with increased competition for land, and so that can certainly affect a tenant's willingness to pay or invest even more into some of these practices. Maybe the incentives aren't there. They're just not sufficient incentives to change how that operator operates, or to convince that landowner that this needs to happen. We can also have some challenges with management and technology. Do we know how to engage in these new practices and have the technology to adopt them effectively? So a lot of peripheral issues that can come into that conversation if you want to try to create a leasing situation that does address these practices more. Robert, thoughts on any of that as a practitioner who's written leases?
Yeah, it's, it's a worthwhile endeavor, but it's not without its challenges. And I think the good starting point is having landlord and tenant, really on the same page as far as what are they trying to accomplish. Is minimum tillage important to both? Then we kind of got common framework to move ahead with, but it can be challenging.
Definitely. And challenging, even if we agree that we're on the same page, how do we agree to how we're going to present that agreement? Right? How do we agree to the terms of what we think we want to accomplish? Those can be definitely difficult issues to overcome. So we talked a little bit about incentives, and I know, Robert, you have said before, there need to be incentives on both sides of this, right?
Mhm.
For both the landowner and for the tenant operator, certainly to engage in that. And we have seen an evolution in my time as an attorney where government programs were the primary source of funding when we refer to financial incentives. But increasingly over the years, we're seeing more nonprofit and private institutions engage in providing financial incentives for conservation practices. And then, as you know now, there's an evolving market-based incentive approach, especially when we're talking about carbon and ecosystem services, where we're bringing those, again, the kind of the private interests into a market-based approach to providing financial incentives for these types of practices. And so there's a lot to work through as we consider what might be some options, some programs to engage in if the goal is to try to adopt more practices. There's a lot more choice now, and the menu is growing in different ways to go about trying to obtain some of those financial incentives that can make it worthwhile for both or either party. When we talk about carbon credits and water quality based trading, there's a lot going on in that world right now. I know many of you have probably gotten your postcards from Indigo Ag or the Soil and Water Outcomes Fund saying, hey, we're signing up landowners or operators to engage in this carbon credit program, and we'd like you to consider a carbon agreement, or we'd like you to enroll in this ecosystems benefits program, which is what the Soil and Water Outcomes Fund program is. So these create some unique issues. I think if we look back at just adopting, no-till in our farm leasing arrangement, a little bit simpler, but now we're talking about enrolling in some possibly longer term programs that have expectations beyond just adopting the practice. It may be that you adopt the practice and that practice actually does something, accomplishes something, captures carbon, or we can quantify it. And so there are benefits that we are also bringing into this scenario where it's not just doing the practice, it's also doing it because we think that the practice is aligned with these clear benefits or is going to create something of value like a carbon credit that we can now trade. And so these become a little bit trickier, a little bit more complex. And I want to raise a few issues with them because many of them, and it's hard to see some of these agreements because they are kept quiet and private between that company or that nonprofit and the landowner or whoever's enrolling in the program. But from what I've seen, many of them do have some demands that this practice is going to continue for a period of time, and that there isn't going to be any activity that would interfere with the benefits that we think will come from the adoption of these practices and this agreement that we're putting in place. So a little bit different situation where we have this third party now expecting some value and benefits from the adoption of conservation practices. I also want to point out that sometimes it may be a tenant operator who goes and enrolls, or the landowner who goes and enrolls, but we really need both of them to be on board to make these arrangements work. Many of the programs require landowner approval. So that's a first step, a first eligibility requirement. If an operator is trying to enroll in a carbon agreement, they may want to see that your landowner is okay with it. And that's because of that long-term continuity that I raised earlier. And we would have to question whether the operator could actually enroll the land in the program, because the operator is not the owner of that land. So we've got some discussion that needs to take place then between the owner and operator to make sure that they're both on the same page, and that the one who has the authority to participate is certainly on board with that. And many have asked me, they're looking at payments, the Biden administration in the Build Back Better Act that has not passed, but we may still see this piece come. They were offering flat out $25 an acre for doing cover crops. So who gets that? We need to negotiate who gets some of the benefits of these types of programs, and who gets the benefit of the carbon credit. If the farmer who's operating adopts a practice that generates a carbon credit, should all of that value of that credit go to the operator? Should it be shared between the landowner? Should all of it go to the landowner? We need to work out some of these issues when it comes to payments for these kinds of conservation practices and benefits. And then there are also issues, as I mentioned before, with this being a long-term arrangement. Well, we've got to look at liability for the potential violation or degradation of those benefits out into the future. What if the tenant operator is gone and something happens that reverses those, as well as trying to combine these programs with other programs that the operator or owner may be already participating in. So it's a lot to think about, and I certainly don't expect to work through all of that now, but I raise that because I think these are issues to start working through if you're interested in going this way. And we are hearing more and more from both sides of the leasing arrangement and trying to decide whether these are programs that they want to pursue. So just a wrap up, program choice is something to address. Who gets to choose which programs? Are you both on the same page? How are we going to share those program payments? What about the cost of the practices? We may need to look at those, and the payments. Again, if we don't have a program payment, how are we going to address the cost of the practices and the payments without that program payment? What kinds of impacts might we see on production and yields, and how are we going to address that if there is a decrease in production that the tenant suffers because the landowner wants these practices in place? And then again, long-term security can be helpful in these situations where we may want to go from a 1-year renewal lease to a 3 or a 5-year lease to create some stability in that relationship. And then finally, reimbursement upon termination if some of those practices will continue to provide benefits to one party or the other, typically the landowner. How can we address that? So I threw a lot at you. Robert, is there anything you'd like to say about any of that?
A little bit related to it, but a thought popped into my mind that might be interesting to some of the participants, and that is on the conservation side. We often get situations where we got a farm that sits wet and it needs tile, and the tenant would really like to have it tiled for production reasons. And the landlord understands the value of the tile, but they don't want to spend $1,000 an acre. Could be 5 years worth of rent to pay tile. That's tough on the landlord too. Where we use long-term leases is to address this issue many times, where maybe we'll do a 10-year lease and the tenant will put the tile in, the tenant will pay for the tile. And in exchange for doing that and improving the land for the landlord commits to maybe a 10 or 15-year lease. But if the landlord terminates the lease early, then they reimburse the tenant for a pro rata share of the cost of the tile. So just as kind of as you were going through things, that popped into my mind. That might be if any of our participants are in that situation, that could be something to think about, using long-term leases to address
Good.
land improvement.
Good. And we'll get you in the long-term lease topic here in a moment to talk about how that can be helpful for succession planning as well. I'm going to wrap up by going through some of the steps to ensuring that a lease is enforceable. And hopefully, you know what I would say first, and that is that it should be in writing. That avoids having to try to take it to a court of law and prove that the statute of frauds should be set aside. So putting it in writing, and it has to identify the land, name the parties and landowners, have the proper parties sign the lease, all of them. And then that question about acknowledgement, a lease over 3 years under Ohio law has to be acknowledged and certified. And we've removed the witness requirement. Acknowledgement now is that you can go before any local official, or a notary, of course, could do that. A notary or a local official can acknowledge that your signature to that lease. It's a simpler process. The law changed a few years ago to accommodate that kind of an acknowledgement rather than having several witnesses, but a notary will suffice as well. And what they're acknowledging is that you voluntarily sign this agreement. It's your own free will. And then the final step to ensuring that that lease is enforceable is recording the lease. Now, you don't have to do this by law, but the law allows for it, and it's certainly a protective measure to take. And so you could run into some problems if you don't record, because you have not put others on notice. And so others that may have an interest in that land could have a valid argument to say that they did not know of this leasing situation. Once you record, then the world is put on notice. The world is assumed to know about your leasing arrangement. But you don't have to record the entire lease and divulge all those details. Certainly don't have to divulge the payment, the rental amount, those financial arrangements that you've made. Ohio law allows you to record a short form that we call a Memorandum of Lease. And that Memorandum of Lease only has to contain those parts that you see here: the names of the parties, the legal description of the land, the period of the lease, and whether there are rights of renewal for that lease. Those provisions have to be in that memorandum, and both parties sign that, take it down to the county recorder and record it. And now the world is put on notice that this lease exists. And so that's an important step in the process. That's why back in when I was talking about terms to include in your lease, agreeing that both parties will sign the memorandum, and then someone can take it and have it recorded. We need both parties to sign that. So Robert, that's a typical practice that an attorney will do, is have you sign the lease, you also sign a memorandum.
Yeah, there's really no reason to record that lease. It really should not be recorded. They just do the memorandum instead. Always.
Oh, I thought, Ramon, you were saying not to record the memorandum of lease.
No. Sorry about that. No. Yeah, do not record the lease. Record the memorandum instead. It's easier and protect all that private information.
Yeah, usually just one page, simple.
Yeah.
So we know the lease is there, but no one has to know the details except when does it end? Is it going to renew over into the next year?
Mhm.
Good. Okay. So I have all of that summarized for you in a law bulletin. Some of you were asking for our farm office website. It's farmoffice.osu.edu. If you go to that site, we have an ag law library option, and you go into our library and you'll see our farm lease materials. There's the lease checklist, there's other materials on farm leasing. And we have also included a link to that on the page that Barry mentioned earlier, where the slides and the webinar recording will be as well. You can access this page there, but that's all there on farmoffice.osu.edu in the Ag Law Library. And with that, I'm going to turn over to you,
All right.
Robert.
Well, Peggy, we got a question. Can only lawyers draft a legal description of land?
Actually, it has to be based on a survey.
Surveys, right?
Yeah.
So Lauren, if that's what you mean, like the actual, you go 100 feet and then turn 20 degrees, that has to be done by a licensed surveyor, and then it's approved by the county engineer's office. If you mean something different than that, let us know. But yep.
Yeah, and lawyers often will copy that over and attach it as the legal description. We can do that, but yeah, we can't actually create the legal description.
No. Okay.
Good question.
All right, let me see if I can share my screen here. All right, I think that worked. So I'm going to talk about using leases and farm estate and succession plans. Now, I did say many of you are landowners only. These slides have to do more with the succession plan for the actual farmer, but hopefully some of it may be applicable, or maybe you find some of it useful to you. I did want to address the question of somebody to ask, why would you put land in a trust? I could talk an hour about that, but I'll give you a 15-second answer. One is it can avoid trust or avoid probate. And also there's a lot of good estate planning strategies to put a land in trust. A trust can allow you to basically control the land from the grave. You can put conditions on it. You can hold it in trust for a long time. You can say you can't use the land for this reason. So many good reasons to use a trust. And talk to your estate planning attorney about if a trust might be suitable for you. But trusts are generally an estate planning strategy. So leases can be a good way to transfer land to off-farm heirs while still protecting the on-farm heir. So, when we do estate planning with farmers, we get into this dilemma on many, many farms is almost all the assets are farm related. But if you have, an off-farm heir, meaning a non-farmer, and an on-farm heir, if the farming heir gets all the farm assets, then it's, a lot of times it's very unfair to the off-farm heir. And so what we'll do is sometimes we'll allow the off-farm heir to get some of the farmland, but we then require through a trust, oftentimes, will require that off-farm heir to lease it back to the farming heir. So it's a way to get farm assets to the off-farm heir while still making it available to the farming heir. And would not recommend doing this through wills or probate. We just don't want to get hung up in probate. Much better to do it either while you're alive or through your trust to avoid probate. So the concept here again is that we make the farming heir, I actually have that wrong. The farming heir is the lessee, and the non-farm heir is the lessor. And so the non-farm heir will receive income, rent from the land. So that gives them value for that asset. But at the same time, we're keeping that that land base available for the farming heir. Avoids joint ownership of land. Sometimes we'll work with clients and, mom and dad will say, my kids will not get along if they own land together. They're just going to fight about it. I need to give, each of my 3 children a farm, but the one is farming. How do I make sure that, that land is available for him to farm and they don't get mad at each other and, the siblings lease it to the neighbor because they get mad at them. That's what a long-term lease can do, is you can give ownership of land to off-farm heirs, but ensure that that land base is still available to the farming heir. How long should the lease be? Through Peggy's section, we were talking about, 1 year, 3 year, I mentioned 10-year lease for maybe tile improvements, but the term of the lease in this case may be much longer. And typically we want the lease to cover the farming career of that farming heir. So if the farming heir is 40 years old, maybe that lease needs to be 40 years long. Leases can be up to 99 years. We do have some 99-year leases out there because we got children and grandchildren that are going to be farming. So these often are long-term leases. It's your land, it's your decision. You might think, am I really allowed to put a 50-year lease on my land? Yes, you are. And if that's what it takes to protect the farming operation of the next generation, and that's important to you, then that's what we ought to consider doing. Rental rates. So anytime we go a long-term lease, we got to have a way to adjust the rental rate. And, probably anything over 3-5 year lease, we really need a mechanism to adjust, because you're just asking for, you get into a 20-year lease and it's $150 an acre. Somebody's going to be really mad year 19 and 20 because it either went way up or way down. So if you go to a long-term lease, make sure there's that rental adjustment mechanism in there. And different mechanisms that we use, you try to have the parties agree to it first, but if they don't agree, you can go with published rates like Barry was going over before, or maybe you agree on a neutral third party that comes in and says, here's what it would rent for on the open market. Also, don't be afraid to include a discount. This is very common as well. We may say, okay, the farming heir has a right to lease the land on a 20-year lease, and the rent is 75% of fair market value, just so you're not competing with, the $250, $300 an acre rents out there. Just helps take the edge off a little bit for the farming heir if you want to help the farming heir out a little bit. I just went through that. By mutual consent should be the first option. If you can't agree, either an appraisal or publish lease rates. And as long as they're available for your area, Barry was saying over in Eastern Ohio, cash rent rates, just aren't as prevalent. And if you own river bottom ground and Washington County average probably isn't going to be right for you. So just keep that in mind. What do these long-term leases do? And when I'm working with clients on this, I want to be cognizant of, what does this do to both the farming heir and the non-farming heir? And I think part of advising a client is making sure that, you are informed. Here's the pros and here's the cons. So long-term leases for a farming heir is mostly positive because they know the land base is available to them. If we use any kind of a discount, they don't have to compete with, the guys paying top dollar for everything. Also gives them a lot more security. They can do a lot more long-term planning. Whereas if, their siblings own the land and kind of a tenuous relationship and they're like, well, I don't know if I'm going to be able to lease it in 2 or 3 years, may really impair their ability to do long-term planning and grow their operation. Now, I will say that the impact on the non-farming heirs and my impact is mostly negative from the sense of, they own an asset that they're really limited as to what they can do with it. So, if they own a farm, great, but if it's locked up in a 20-year lease and the rent's 75% of fair market rent, who's going to buy it? So it definitely limits the use of that. It would probably limit the use of for solar, mineral rights, wind, things like that. It can cause hard feelings and jealousy. It's like, why does, the farmer, get all the benefits, and just because I went and did something else, why is my land tied up? I can't just go sell it, cash out, and move to Florida like I was planning to do. So all of these need to be taken into consideration before you add a long-term lease to your estate plan. But I think it is worth considering in some situations. So just finish up here with an example. You got 2 100 acres farms. We got one child that wants to farm or is farming, one child that went off and did something else. In mom and dad's trust, it says distribute one farm to each child, and then the farming child has the option to lease the land up to 20 years. And then the rent has a 25% discount off of the county cash rent average. Every 3 years, we renegotiate the lease, and if they can't agree, then we go to that cash rent average for the county. And you can include a provision that, okay, the off-farm heir can sell the land, but the farming heir gets a first chance to buy it. You can add a discount in it for that. So should you have a long-term lease in your plan, you can read the yes and no's there. I'm just, the point of this this part of the presentation is just wanted to make you aware that it is a tool we can use, is a possibility. You may want to think about it, but it's certainly not for everyone. All right. 3 minutes to spare. So.
Oops. Barry's back with us. Are there any final thoughts, questions, Barry, we need to address?
I think we touched on everything that I saw in the Q&A and the chat feature. We put a number of websites up, including again, the webinar resource page. So hopefully you can find the information there, and we'll have the recording posted here within the next couple of days. So
Okay.
I think that concludes things, unless you guys have any last thoughts for this evening.
Well, my final thought would be good luck on the next crop year. And if you don't have that lease in writing this year, maybe shoot for it next year. Any thoughts from you, Robert?
No, I think those are good parting comments.
We want to remind you once again, we value your feedback. So when you depart the webinar, you'll be given a link for our evaluation. So we would ask you to spend a couple of minutes giving us a little of your time and information. And thank you, and have a great year.
Yep. Thanks. Good night, everyone.
Thank you.
Do you want to stop the recording, Barry?
Yes.